Okay, so there's another new law taking effect in 2025. If you're watching this today, April 1st, 2025, this is not an April Fool's joke, although it probably seems like it at this point if you're a California landlord. This is a new law that you may have to comply with if you're a California landlord. So let's get right into it. I am a lawyer. I feel like I have to give you a bunch of disclaimers, which lawyers always do. I'll save those for the end so you can skip past that and get right into the meat of it. All right, so let's get right into it. I'm going to keep this as quick as I possibly can because I know you are as busy as I am, most likely. So let's break this up into the 5 W's plus a how. What? What is AB 2747? AB 2747 is a new California law that was codified into law by adding a new section, specifically 1954.07, to the California Civil Code. What AB 2747 provides is the option to tenants to to have their landlords report positive rental payment history to consumer reporting agencies. Let me say that again because I fumbled the words. I'm sorry. It provides the offer to tenants to allow their landlord to report their positive rental payment history to consumer reporting agencies. Now, why is this being enacted? Why was it even being contemplated? The apparent goal of AB 2747 is to provide tenants with opportunities to enhance their credit worthiness through the voluntary reporting of positive rental payment information. So, the who. In general, who does this apply to? What properties? AB 2747 applies primarily to multifamily buildings with 16 or more residential units. So in this case, when we were examining whether you're covered by AB 2747, it looks at not necessarily who the tenant is. That's not important. It looks at the nature of the property. And if the property has 16 or more units on site, then it's covered and the landlord has to comply with AB 2747. Now, that's an oversimplification of eligibility, but if you have 16 or more units, then at least you have to comply. Now, there are exceptions. If you have 15 or fewer units, you may be exempt. In most cases, you will be, but there are exceptions that could repeal your exemption. So, of course, talk to a lawyer if you can afford one. If you can't, here's basically what you need to know to determine whether your multifamily property may still be covered under AB 2747 if you have fewer than 16 residential units on the property. It may be covered if you own more than one property. It may be covered if you have non-natural person owners, such as REITs, LLC members. So that's where you need to really dive in a little deeper and get more information, ideally from an attorney, but at least read the bill. Read Section 1954.07 of the California Civil Code, and it specifies those additional exceptions and exemptions. So if you have tenants who expressly waive their right, that is their option. They don't have to comply. This is a right, but not an obligation for tenants to have their positive rental histories reported. Now, if the tenant opts out by expressly doing so, then they're blocked for 6 months from participating in the positive rental reporting program. And if they fail to pay the reporting fee, as I'll address in just a couple of minutes, then they also are locked out of the program for 6 months. If they just don't respond to the landlord offering this service, that doesn't necessarily count as an affirmative opt out. So they have to make an express waiver or decline of the offer. Okay, now the when. This is important because the reason I'm making this video today on April 1st, no, again, AB 2747 is not an April Fool's joke, even though it may seem like one from the California legislature. April 1st, 2025 is the date that compliance begins for existing tenants. And if you're watching this, this is last minute. Hopefully you should have already complied by notifying your existing tenants of their right to begin having their positive rental history reported. Technically, I believe April 1st would have been the first month where the landlord can and should report if the tenant opts in. There may be, I'm not telling you this legally, there may be, and again, this is not clear, but there may be some wiggle room. April 1st has probably come and gone. It's not too late for the landlord to report the positive rental history if you do it quickly. That's up to you. You should comply to the closest letter of the law. Doesn't matter if it's inconvenient or you didn't know or it's not something that you think is important or you don't think your tenants are going to want that. Those are not decisions that you get to make. Those are not valid answers that you can provide to insulate yourself from liability. There are many things that you can get yourself in trouble for as a California landlord. There are probably even more things that you don't even know that can get you in trouble for non-compliance. So do everything that's within your control, because things in life are always outside your control and they will surprise you at the worst possible time. So starting no later than April 1st, 2025, preferably well before, the landlords should have notified their tenants that are pre-existing of their right to request the positive rental reporting. For the other tenants, those who don't have leases that currently exist, but for leases that begin today, April 1st, 2025, and any day subsequent, then you need to notify those tenants. For those tenants, now you can start to automatically include a form in your new lease agreements. If you are a property with 16 or more residential units, or you qualify under one of the exceptions and therefore are covered. So you should have two different forms, just to summarize. One for your existing tenants, call that Form A, and then one for all their new tenancies that begin today and any day after. And that is an addendum to your current lease. Another when. When and how often does the landlord need to subsequently remind their tenants of the offer to report the tenant's positive rental payments? Well, regardless of whether the tenant moved in prior to, on, or after April 1st, 2025, the landlord needs to notify the tenant once per year of the tenant's rights under AB 2747. If you need more detail on this, first look at California Civil Code section 1954.07, subsection C, like Charlie, before you spend your precious money for $500-$600 an hour on an attorney. Answer as many of the questions as you can, so you'll at least whittle down the amount of questions that you weren't able to answer yourself, for which you can then spend the money on an attorney to get things deconflicted. Okay, where? Going through the 5 W's here. Where? Again, AB 2747 is not a national law, nor is it a local ordinance. AB 2747 is a California statute that applies to basically all multifamily properties with 16 or more residential units, as well as multifamily properties that are otherwise subject to an exception from that exemption, as I discussed earlier. I know it sounds technical, but it's at least applicable to multifamily properties with 16 or more residential units. It is possibly applicable to residential properties with fewer than that under certain conditions. Why? As we talked about at the beginning, the why of this is to allow tenants to build their credit through consistent on-time rental payments. Basically, in case you're not aware of how credit reporting agencies work, they feed off of good news and bad news. If you have a late payment that is reported to the credit agency, that's where your credit report goes down. All the opportunities you have for positive rental reporting can only help. It may not help, but it can only help boost your FICO score and get it towards 850. And when that happens, magical things start to happen. And if you aren't aware of that, then you probably should watch another video, because I'm not going to spend the time on something outside the scope on this video about AB 2747. Additional details. So positive rental payment information under AB 2747 under the Civil Code is defined as on-time, complete rent payments. It does not include late or missed payments. That would not be a positive rental payment. The fee that a landlord can charge right now is capped at $10 a month, and it may be lower than that. It must reflect only actual costs. So it can never exceed $10, and it cannot exceed what the actual cost of the landlord for reporting and compliance are, because some of these third-party services that aggregate the data may charge the landlord a fee to comply. And the how. Okay, so wrapping up, how can a landlord comply with AB 2747? So I'm not going to just knee jerk automatically tell you to hire a lawyer, but I'm also not going to tell you to do it yourself. So if you're watching this, then it's assumed you may not be able to afford a lawyer, or maybe you can, you just prefer to do things yourself. Even if you can afford a lawyer, I still recommend you learn as much as you can on your own to reduce the number of questions and ask better questions when you do eventually have to pay for a lawyer. Now, for the rest of you landlords who are inclined to take the risk of trying to comply with statutes like AB 2747 yourself, keep in mind that the money you may ostensibly be saving up front by not hiring a lawyer can quickly be completely erased by just one mistake if you didn't even know what you didn't know at the time. The costs for reversing a mistake are often multiples higher than paying someone competent to do it correctly the first time. I don't need the business. I'm not doing this to market myself necessarily. I do it to help out. And if I get leads from it, or I get connections with my local bar association in Southern California, San Diego specifically, I also have clients up in Northern California, then great. But that's not my primary purpose. This is something that a lot of landlords don't even know exists. Other landlords know it exists, but don't know when it applies or how it applies. So that's the point of this video. Now, despite the necessary caveats that I just gave you, here are the basic steps that you need to follow to comply as a landlord of properties that are subject to AB 2747. So the offer that you make to your tenant must be provided in writing, by mail, or email. And in case I really need to say the obvious part out loud here, that means that a conversation that is not in writing, that is not in email or writing or mail, will not suffice. You will not satisfy your statutory obligations as the landlord under AB 2747 if you just have a verbal conversation. You should know by now, if you've been doing this long enough, stop just having verbal conversations. Put things in writing. If you do have a verbal conversation, follow up with preferably an email or a text or some kind of writing to protect yourself. If you are mailing the notice, then you must include a self-addressed stamped envelope for the tenant to send a response at your expense, not their expense. If you need more information on this provision, look at California Civil Code, obviously 1954.7, but subsection Delta, subsection 4. And then finally, as I touched on how much it costs, because there is a non-zero amount associated with the landlord's reporting obligations, the landlord can report and charge a fee for the report up to $10, not to exceed that, as I talked about earlier. But here's what I didn't mention. If the tenant fails to pay the fee for 30 days or more, then the landlord's only remedy is to stop reporting the tenant's rental payment information. And the 6-month lockout for the tenant to participate in the positive rental reporting will also take effect. Again, that's the exclusive remedy. You can't deduct from a security deposit. Don't take any other self-help measures after that. So if you found this helpful, please let me know and I'll make more of them. If you have suggestions for other topics that would be helpful to you, then it would be helpful to me if you let me know. And of course, helpful to me if you like and subscribe. It helps the algorithm. And here are the caveats that no lawyer can resist slipping in. I am a lawyer. I'm not your lawyer unless you and I have an active representation agreement in force. These are informational videos only. This is not to be construed as legal advice that is specific to anyone's individual needs. This is general information, and I am making this for no reason other than to help clarify some of the convoluted statutes that our California legislature puts out. It is very difficult to draft legislation that is both clear and comprehensive. And I'm not faulting the legislature, but there is a reason why lawyers have always been necessary, are necessary, and well, notwithstanding AI, may always be necessary in the future. I know not everybody can afford a lawyer, so I hope this maybe helps at least one or more persons. Thank you for watching. Your time is valuable, and I appreciate it.